The third step of the negligence analysis is the causation inquiry. On a balance of probabilities, you have to prove that the harm would not have occurred but for the defendant's conduct. See, for example, Barnett v. Chelsea and Kensington Hospital Management Committee, 1968. Here, a couple of guys get arsenic poisoning from drinking tainted tea. They vomit a bit but seem otherwise fine. They visit the hospital, and the doctor refuses to examine them because they seem fine. So, the doctor had a duty of care to the guys, and he failed to meet the standard of care. Both patients died shortly after leaving the hospital. But the trial judge found that by the time they got to the hospital, it was too late for anything to be done, even if the doctor had been trying his best. Causation thus failed, and the doctor was acquitted. For some more guidance on how to conduct the counterfactual evaluation required for the but-for test, see Arndt v. Smith, 1997, 2 SCR 539. The plaintiff got a pox during pregnancy and gave birth to a disabled child. She sues her doctor since he failed to inform her that having chickenpox during pregnancy increases risk of disability. The woman claims causation on the grounds that she would have had an abortion if she knew the kid had a higher risk of disability. The doctor raises doubt about that and wins at trial, then loses at the appellate court and wins again at the SCC. According to the SCC, the counterfactual test is half subjective, half objective. To see whether the injury would have occurred but for the defendant's conduct, we must ask what a reasonable person in the plaintiff's shoes and possessing the plaintiff's beliefs/expectations insofar as they are not unreasonable would have done. Applying this, the court held that it is appropriate to infer from the evidence in this case that a reasonable person in the plaintiff's position would not have decided to terminate her pregnancy in the face of a very small increased risk to the fetus posed by her exposure to the virus which causes chickenpox. So, no causation was found. She would have given birth to the deformed kid whether or not the doctor warned her about the slight risk of deformity presented by chickenpox. Some additional rules help us apply the but-for test in more complicated cases. First, there's the thin skull rule. Once you prove that the defendant caused the harm, the defendant is on the hook for the full extent of the damage caused. The defendant must take the plaintiff as they are, even if the plaintiff's pre-existing conditions cause them to suffer more damage from the defendant's conduct than a normal person would. You can see this in action in Athey v. Leonati. It has long been established that a defendant is liable for any injuries caused or contributed to by his or her negligence. If the defendant's conduct is found to be a cause of the injury, the presence of other non-tortious contributing causes does not reduce the extent of the defendant's liability. That case also states that damages for past conduct do not depend on how likely that conduct or its damage was. Past events must be proven, and once proven, they are treated as certainties. In a negligence action, the court must declare whether the defendant was negligent, and that conclusion cannot be couched in terms of probabilities. Basically, everything flows from the general rule that the plaintiff must be returned to the position he would have been in with all of its attendant risks and shortcomings, and not a better position. Second, the crumbling skull rule. If the plaintiff's injury would have occurred at some point in the future without the defendant's negligence, then the overall damages can be reduced. The defendant successfully argued this in Jobling. The defendant injured the plaintiff's back, putting him mostly out of work. An unrelated disease was discovered before trial, which will render him totally unable to work after some more time passes. So, is the defendant liable for all the damage they would have caused in the absence of the disease? Or do they just owe for the days that the plaintiff could have worked before the disease took its full effect? The law says option number 2. Third, it's worth taking note of Section 1 of Ontario's Negligence Act. I'm not going to quote it verbatim because you can look it up yourself, but this provision basically allows judges to apportion damages between tortfeasors and allows defendants to seek contribution and indemnity costs from each other in case the plaintiff doesn't bother suing more than one. Individual defendants remain fully liable to the plaintiff. So long as the plaintiff can prove negligence by one of the defendants, they can pretty much always recover the full amount of damage suffered. While not usually referred to as rules, we should discuss a few more key topics. Related to the thin and crumbling skull rules, is the common law treatment of concurrent tortious causes. You might notice some tensions between the cases I just talked about and the ones I'm about to get into. But generally speaking, you should trust Canadian cases more if you're in Canada, and you should weight newer cases more than old ones. Accordingly, you should probably trust Athey and/or Jobling over Baker, Kingston, or Lambton in cases of contradiction. But if you want to make extra sure which applies, or if they can be reconciled, get on Lexis or Westlaw and see how the cases here are respectively treated by recent cases in your province. With that disclaimer out of the way, let's do more cases. First is Lambton v. Mellish, 1894. Here, two caterers keep organs and merry-go-rounds on their property. The nonstop music is maddening to the neighbors. A neighbor sues them for nuisance to get an injunction. Defendant 1 had swapped out his large organ for a smaller one before the lawsuit. It was the other refreshment contractor, Defendant 2, who was using the real bad, real loud organ. So Defendant 1 claims he is not liable. The court says that is no excuse, as he still contributed to the nuisance. You don't have to show how much of the nuisance is caused by a person. If they contribute to it, you can sue. In the court's words, if the acts of two persons each being aware of what the other is doing amount in the aggregate to what is an actionable wrong, each is amendable to the remedy against the aggregate cause of the complaint. In Kingston v. Chicago and Northwest Railway, 1927, sparks from the defendant's locomotive started a fire, which subsequently merged with a fire of unknown origin 940 feet away from the plaintiff's property. The united fire then destroyed the plaintiff's property. Basically, Lambton is reaffirmed, but this case clarifies that the defendant can still get out of liability if they disprove but-for causation. I quote, "It is settled in the law of negligence that any one of two or more joint tortfeasors, or one of two or more wrongdoers whose concurring acts of negligence result in injury, are each individually responsible for the entire damage resulting from their joint or concurrent acts of negligence." Granting that the union of that fire with another of natural origin, or with another of much greater proportions, is available as a defense, the burden is on the defendant to show that by reason of such union with a fire of such character, the fire set by him was not the proximate cause of the damage. The defendant was unable to meet this burden and was held liable. In the House of Lords case of Baker v. Willoughby, 1970, the plaintiff was injured by the defendant's negligent driving and sues. His leg is hurt, so he can't work. After the accident, but before trial, he gets shot in the leg by robbers. The motorist defendant says he is not liable for the plaintiff's lost work time after the shot, since he would have been unable to do that work anyways. The judge says it does not matter, and holds the defendant liable for the full amount of lost work time. Concurrent tortious causes do not reduce the defendant's liability, but again, this conclusion could be considered questionable in Canada, given Jobling and perhaps Athey. But that's enough about concurrent causes. The UK House of Lords has recognized loss of chance as a form of damage that can give rise to liability and negligence. According to Greg v. Scott, 2005, "You would likely have gotten hurt anyways" is not a defense if the defendant seriously contributed to the likelihood of the victim getting hurt. The loss of chance doctrine, as per this case, states that a defendant is liable for a plaintiff's losses if they increased the chances that such loss would occur, even if they did not cause the outcome itself. Unlike the UK, you cannot sue for loss of chance in Canada, or at least in Ontario. This is established in Cottrell v. Gerard, 2003, at the Supreme Court of Canada. Here, a toe sore turned to gangrene and an amputation became necessary. We don't know whether or not the foot could have been saved if the doctor had examined the sore. The patient sues the doctor for blowing the window of opportunity. The Supreme Court swatted her down, since she could not show that the gangrene would not have occurred but for the doctor's refusal to examine the sore. Causation is established where the plaintiff proves on a balance of probabilities that the defendant caused or contributed to the injury. You will also find a material contribution to harm test applied in some cases. I'm pretty much going to ignore this, since it's basically just the but-for test with extra steps. Essentially, it states that the defendant can be found liable even if they are not the only or the main cause of the defendant's injury. A defendant will be held liable for the entire injury if their action was a necessary contributing cause to the injury. There will always be non-tortious contributing causes to any injury due to the nature of causal reality itself. If these causes protected the defendant from full liability, then plaintiffs would never be made whole. See Athey v. Leonati. The main thing you have to remember is that material contribution to harm is not the same thing as material contribution to risk. You may be wondering what I mean by material contribution to risk. Well, it's a very niche exception to the but-for test, applicable when we know that negligent conduct within a discrete group of people caused the injury, but we can't pinpoint which individual within the group caused the harm. See Clements v. Clements, 2012, which explains the test, though it does not end up applying it. If it's possible to get an answer from the but-for test, then you should use the but-for test. My favorite application of the MCR test is Cook v. Lewis. Two guys were hunting birds, and they discharged their shotguns in the same general direction at the same time. There was a third guy in the bushes who got hit with the birdshot and lost an eye. But we don't know which of the shooters fired the shot that hit the plaintiff, since it was found that both shooters were negligent, but only one hit the guy and they could not tell which. They both had to pay. Another successful use of the MCR test is Fairchild v. Glenhaven. Here, a guy got mesothelioma due to asbestos. Mesothelioma, if you were unaware, is caused when a single asbestos fiber does the wrong thing in the wrong place at the wrong time. But the plaintiff was negligently exposed to lots of asbestos by multiple employers. We do not know which employer exposed him to the specific asbestos fiber that gave him the mesothelioma. So, as in Cook v. Lewis, all the employers were found liable for the mesothelioma. So, that's causation in a nutshell. The next step in negligence analysis is remoteness. See you soon.